Welcome to our new series on AI. Over the coming months, we'll explore the key challenges and opportunities within the rapidly evolving AI landscape. Today, we will focus on AI in international arbitration. We'll discuss the integration and adoption of artificial intelligence in international arbitration. I am Niyati Ahuja. I'm a senior associate in the Global Commercial Disputes Group in our New York office. I'm joined by Antonia Birt, who's a partner in the Global Commercial Disputes Group in our Dubai office, and Rebeca Mosquera, who's a senior associate also in the Global Commercial Disputes Group in New York. I am going to discuss about adoption of artificial intelligence in document review and analysis automation. As we have come to know, artificial intelligence-powered tools are already and increasingly being used at virtually all stages of international arbitration proceedings. And its potential for transformation is already quite evident. Artificial intelligence tools can review and categorize vast amounts of documents and data quite quickly, making it easier to identify relevant evidence, reducing time and cost associated with document review, as well as making our life easier. Generative AI tools are trained on vast data sets and have exceptional capacity for natural language processing, which allows them to rapidly search, to compare documents, to summarize and extract insights from large volumes of texts, images, and even scanned documents. By using continuous active learning technology and large language models, platforms like Relativity can significantly streamline the review and disclosure process, and also improve the accuracy of the review. This is achieved by artificial intelligence relying on samples of documents reviewed by lawyers and self-training to detect the key issues, while constantly re-ranking unreviewed documents based on further lawyer inputs. I'm not saying that lawyers can completely extract themselves from the procedure, but it can certainly be a huge cost and time saving for lawyers as well as clients. Personally, I've had one of my cases had about over 150,000 documents which needed to be reviewed in a very short period of time. That's where AI really helped us, and we were able to see how useful AI could be in practice. As I just mentioned, basically we train samples of documents, which helps AI self-train to detect the key issues and rank documents as most likely to be non-responsive. And that definitely helped us decrease the universe of data and documents that were supposed to be reviewed. So that's how AI has helped me, and that is only one of the ways AI has helped us in document review and analysis automation, but there are so many more. And the other speakers today, Antonia and Rebeca, will discuss a few of them. So now over to Antonia.
Hello, everyone, and thank you for joining our new video series. Thanks also for Niyati for the introduction and the comments on the use of AI in document review and analysis. Niyati rightly pointed out how AI is already transforming this area, which is addressing a real pain point in arbitration. Document review has become particularly challenging and time-consuming. AI is now widely used in the field, in fact, often without users knowing it. Niyati mentioned already TAR analysis, which is extremely useful in identifying more likely responsive documents. And of course, recent developments in generative AI progressing that field as well. But moving to our next topic, I would like to discuss how AI can help with international arbitration procedure and case management. Procedural issues are crucial in arbitration. They can influence outcomes of proceedings. They can facilitate early settlements of disputes. Of course, an early settlement is a real win in an arbitration proceeding, and hence the focus on procedure, arbitral procedure. On the other hand, of course, case management and procedure also pain points in arbitration proceedings. They can be time-consuming, costly, administratively burdensome, And that's why, in my view, this is an excellent area for AI innovation, and one that I'm sure we will see more changes in the future. For the time being, I would say AI is not yet significantly used, but it is beginning to make its mark. And I wanted to address 3 examples of where AI is starting to help with case management. The first one is possibly the least well-used one to date, which is the use of automated case management systems. Systems are now becoming available, steadily entering the market, which allow to automate cases, deadlines, procedural tasks internally and potentially also externally with respect to procedural timetables and other parties that are involved in the tribunal. Doing this can obviously save significant costs typically incurred through manual effort undertaken by associates, and indeed can at times avoid delays or mistakes. The second is a much more widely used application of AI, one which is growing, however, which is the automatic recording and transcription of procedural and other meetings. So meetings, including procedural meetings, but also meetings on a wider level with respect to the arbitration procedure, of course, happen very regularly. And what used to happen in previous days is that such meetings were often either transcribed by transcribers or at least recorded informally, and hours have been spent on these kind of tasks. And indeed, it was often then necessary to go back to previous transcripts, meeting notes, review, analyze, summarize. All of that can now be done automatically. And AI is getting better and better at going the extra mile, so to speak, and providing summaries of meetings, identifying issues discussed, wading through previous transcripts and notes. So an important tool in the overall sphere. And my final example is AI-assisted drafting of procedural correspondence. Again, procedural correspondence is nowadays a very significant aspect of any arbitral procedure and may take up a lot of time and effort. It's not widely used yet, but generative AI is now capable of drafting procedural correspondence, reviewing previous correspondence, identifying key topics that have been discussed, summarizing trends or backgrounds to a particular issue or an application, and of course, even drafting letters and emails. These capabilities are already capable of reducing time and cost involved in these tasks, and I'm sure will continue to improve. I am, for one, excited to see which other arbitration pain points will be addressed by AI in the future. And with that, I'll hand over to Rebeca, who will discuss our final subtopic for today's session. Thank you very much for watching.
Thank you, Antonia. And I couldn't agree more. I think AI in case management, it's a tool that should be used to save time and money. And I think the real value that we can find in the use of AI in case management, it's in the automation of repetitive tasks. This not only saves time, but also ensures consistency and reduces the likelihood of human error. With this, I'm not saying that the AI tool doesn't have limitations. We need to understand those limitations in order to use it responsibly and effectively. And now with that, I want to turn to another very interesting use of AI in dispute and specifically international arbitration, which is predictive legal analysis. And what do I mean with that? What I mean with that is that we're going to take the AI crystal ball and ask the algorithm spirits what will be the outcome of our case. So predictive legal analysis is a game changer, will be a game changer in dispute resolution. AI's predictive capabilities will reshape how we see the landscape, how we how we make decisions about the strategy we'll take in a certain case. By training the AI algorithm on massive amounts of data, we can discover or uncover patterns of behavior, precedents, and how certain things could be the outcome of certain things. But I think the real value of predictive legal analysis at this point in time is precisely uncover or understanding the weaknesses and strength of our case so we can refocus our legal strategy. And this is specifically important in international arbitration or in arbitration in general because of the sometimes the lack of publicly available decisions in commercial arbitration. But with the decisions, what we are asking the AI tool is to predict something very specific, which is how certain arbitrators will decide certain issues. And that's very specific. What we want with predictive legal analysis is something broader, I think, which is to understand what will be the potential outcome of the case. For instance, the AI algorithm can analyze historical data to predict the case outcome, and it will give us an enhanced tool or information of what are our chances to succeed. And so if we understand how to use that tool, we'll have a lot of power in our hands. At the end of the day, the attorney behind this information, it's the last line of defense. We're the ones that understand the case. We're the ones that need to understand the tool, its limitations, and how we can use that information of potential outcome, of weaknesses, of strength to better serve our client. So if I have to pinpoint how this algorithm and how we can train the AI algorithm, the same limitations and the same safeguards should apply that we have been seeing all around or evolving around AI, which is to put around safeguards about safety, privacy, confidentiality. As long as we have those in place and we understand how to use the tool, it will be effective and we can use it responsibly. So to summarize what we've been talking here, I believe that AI is here to stay. I don't think it will take our jobs away, but what I think the main difference or the key difference that we will see, it's between professionals that know how to use the tool, understand it, use it responsively and effectively, and those who refuse to use it or are afraid of using it.